the record of the matter, correct?
Yes, it seems so, because it says here it was then to be delivered the following day, which is a Thursday.
And that's the basis upon which you conclude in paragraph 68 of your affidavit that it's unlikely that he was in a position to render any advice in respect of the Rule 53 record.
Yes.
There's then a memorandum dated 25th July, which is NM6, to your affidavit,
Yes.
right? This is another memorandum which, to the best of your recollection, you did not receive, correct?
Yes.
And you're not sure whether it's in fact an authentic memo or not.
Well, judging from the names on the document, these are names of existing people, but at the time it was, I'm looking at NM7.
6 verse.
Yes, NM6. This is a document I'm complaining about. I'm very much concerned about it. To start with, it's unsigned. Secondly, it does not accord to the way memos would come, would be crafted. There's several things that I can pick up from this document. NM6, the first page of it, it will give you at the bottom page 1 of 1. And it does not give you the name of the subject to identify that the page 1 relates to the FUL case. The font in the addresses is different. The font in the subject is different. You can see the sizes are different as well. Page 2, it doesn't say page 2.
But it also, if you look at paragraph 1.3,
On the second page.
on the
which
second
is-
page,
Which is page 44 of the
yeah,
documents.
the memo is purportedly addressed from Mr. Cheetah to you, and it is nonsensical if he's addressing it to you to say I and Advocate Hatler worked on council's draft, as opposed to reminding you that we worked on it. Don't you
Yes.
think?
Yes, it does not make sense, the 1.3, but then I was not yet done with the flaws that I see here, of which I question this document. If you look at the bottom of this page 44, it says Advocate Mumba/memo. I don't know what this is referring to. It is supposed to then say page 2 of whatever number, and then looking at this document, it's supposed to be having 4 pages. It's supposed to be saying page 2 of 4, freedom under law versus NDPP or DA, if that is the case. It's not doing that, it's not saying that. The contents are inconsistent with what I knew at the time. It's unsigned, I repeat that, it's unsigned. So I
Right.
question the authenticity of this document, and
And
I
this
don't
is one
think-
of the documents that we provided you.
this is a document that you provided to me, and this is the document I also asked from Mr. Krita to provide to me, and I have not received anything of this sort.
Right. And this was included in the documents that was provided to us, as from the documents that came from Justice Yaqub.
That's what I'm told, yes.
Right. Now we come to the matter of Advocate Halgrein. Can we just in short summarize this? You had no knowledge of him being briefed. You were not involved in the brief. You had nothing. You knew nothing about his oral advice, you knew nothing about his written advice, and you knew nothing about him being debriefed.
Yes, his counsel who came and went without me knowing that he
I think he
was-
came and went without you seeing.
Yes, or even hearing him.
Right. So that, but you also point out that when it comes to advice on prosecution matters, if your advice was sought, where would you go on the criminal aspect of the matter?
There is the head of NSSD. If it comes from, say, SCU, I would definitely go there. There's also the head of NPS, who is in charge of all the DPPs in the country. I will definitely go there. But then it will depend on what question is on the table. If I need to consult, I will definitely go and consult with them. And as for me, I'm not an expert in criminal matters, and my mandate at LAD was not to deal with prosecutions. Therefore, it would have been just normal, in the course of events to go and speak to persons that I feel would be knowledgeable to assist me in rendering that advice. And of course, in my training, you don't take a brief that you are not going to be able to handle, And that was a reason acceptable enough to take a brief back, so to speak.
Right, so if I take you to NM7, which is the approval that was sought for the briefing of Advocate Halgrein, and if we just look at the last page, it is a memorandum which is signed by Mr. Chita, Mr. Smith, in his capacity as Director Admin, Advocate Jiba, and Advocate van Rensburg. That in itself is a chain that would permit the briefing of an advocate, correct?
Yes, except if I was part of it, I will also have a signature portion.
As far as you were aware, was there anybody else besides Mr. Chita involved in the lad matter? The full matter, sorry.
No.
In that memo that you didn't know anything about, there's also a second part of the memo deals with the DA case.
NM6.
NM6, that's right. Did you allocate that matter to Mr. Chita?
The DA matter?
Yes.
No.
Were you involved in that matter at all?
No, this matter, this is, no.
Right. Now, you subsequently became aware of Advocate Houders and Advocate Manaka being involved in the full matter. How did that come about?
I was called by Advocate Jiba to come to her office, and when I arrived at the office, I found that there was Advocate Mkhwebi, Mzinyati, Hodes and Manaka, and Advocate Jiba was there, Krita was there as well. And on the table was the FUL matter. And I came to know that they had been briefed to finally deal with the matter. So that's how I got to now know that there's Advocate Hodes and Advocate Manaka dealing with the matter.
And what was your role in that consultation?
To me, I don't know what my role was then supposed to be, because everything, all the documents have been filed. The matter is about to be heard, so no further input really from me was sought.
And what did you learn about the matter while you were in this consultation?
Well, I learned then that there was a supplementary affidavit which was then put up by the applicants, and that in the issues that were, on the table which were problematic was the transcript in the Glenis Breitenbach disciplinary, the inconsistency of the testimony of Advocate Mokgoro and Advocate Mzinyati, and that it's something which I frowned upon was the unsigned statements that were filed by investigating officers in the supplementary affidavit of the applicant. Yeah, which was funny to me, that why would investigators file, you know, they're not even signed, and yet they form part of, you know, the affidavit.
You also discovered the existence of the memorandum which was provided by Advocate, I'm not sure if you said it, the memo that was provided by Advocates Breitenbach and Ferreira. Sorry, I just lost my train of
Oh
thought.
yeah,
there.
that's, I heard that there's at that time there was talk of a 200-page memo. I think this was in the FUL's supplementary papers, that there's a memo which was placed on the NDPP's desk, which the NDPP had not dealt with, and I didn't know of the existence of the memo, and as to what was in the memo, what was complained about in Glenis Breitenbach's memo.
You previously testified that Advocate Mokgoro had told you that the matter had been withdrawn, that Advocate Breitenbach was supposed to look at it, and what your impressions was from that. It was also at this consultation that you became aware that that meeting had actually transpired quite some time back, correct?
That what came out from that consultation was that there was a letter that was issued on the 4th of December of 2012 from Advocate Mokgoro to the attorneys of Mr. Mululi. The 5th of December was then the date on which Advocate Mokgoro, I think, sent a memo to Advocate Mzinyati. And then there was a meeting on the 9th of December where Advocate Mzinyati, Advocate Mokgoro, and Glenis Breitenbach had a meeting. And this is at this meeting of the 9th of December that she was then asked to go and look for the further evidence. But then the parting shot from that meeting was that, well, the matter remains provisionally withdrawn until such time we get the full evidence from Glenis Breitenbach. So then I now learn that the meeting had happened in December, when we had received the FU application was served on us around May of 2012. So these are events that happened in December, and I was not aware of these events, but I would not be aware of them because they're not happening in my office. They are somewhere else, you know, in the operation space between the DPP and the special director. We wouldn't be involved in those meetings.
Can we just go back slightly to the meeting that you were called to in Advocate Chiba's office, where you found counsel Hodes and Manaka and Mokgoro and other people, where you say the full matter was on the table and you had difficulties with regard to the fact that some investigators' statements were unsigned. Did you express your difficulties about this, what seemed to be irregular recording of statements or documentation? Did you express the difficulties that you now say you had?
Well, we all frowned upon investigating officers, all of us, we were of the same sentiment. That, I mean, why would an investigating officer in a criminal matter choose to go and file a statement? Because I call it a statement because it's not signed, it's not an affidavit,
Yes.
but then it was put up in court documents. And yeah, those were, you know, all our, you know, sentiments. But for me, what I tabled was what I then learned, that the meeting occurred on a particular day. This was what transpired. We are now at the tail end of the matter. It's supposed to be heard in court. There's advocate holders and Manaka, and the meeting is almost at the tail end. That's why I'm saying my role was not necessarily, you know, even required in the meeting, because it didn't seem like any input was required from me. But then, for me, these were, you know, surprises that came out of your being in that meeting.
What was the date of that meeting? Do you remember?
Did I write it here? I don't remember. But I'm sure the records will show
They'll show.
somewhere that.
Okay, we'll find it.
Yes.
Thank you. Thank you, ma'am.
So, essentially what you've outlined has been your role in the freedom under the law matter.
Yes.
Right. And if I just take you to some further bits and pieces in your affidavit, it is you then confirm it is not the case that in instances, all instances, that when applications are issued and served on the NDPP, that it is given to LAD.
Yes.
Right. And if the person is designated to deal with it, it could very well be somebody that's designated by the acting NDPP, but you had an arrangement with Advocate Chiba that she would generally go to Mr. Chita.
Yes.
Right. You had no involvement in the poison matter.
No. I did not deal with that matter.
So that is one of the matters that did not go to LAD, as far as you are aware.
Yes.
You eventually, the issue of the poison matter was raised at EXCO, and you asked Gerard Nel to provide some advice. Do you recall that?
Yes.
I showed you the opinion, and you confirmed that that was the opinion that Advocate Nel furnished.
Yes.
Right. And that accords with your memory of what transpired at the time.
Yes.
There was a meeting that you recall attending with General Dramat in Advocate Chiba's office relating to the Mluli matter.
Yes.
Do you recall why you were present at that meeting?
I think I was present in the meeting because the FUL matter was already, you know, in the courts. So I understood that, well, I can be part of this meeting. But then I think I saw the letter that General Dramat wrote to the NDPP where he had concerns about the withdrawal of the matter. And I remember saying to Advocate Jiba, why don't you just phone General Dramat, and so that he doesn't even come to a meeting? Because as far as we are concerned, the matter is just provisionally withdrawn. It has not been withdrawn as you know, but then the meeting happened and I attended the meeting.
And as far as you were aware, Advocate General Dramat was informed at that meeting that it was provisionally withdrawn, and he was satisfied with that.
Yes, and that accorded with what I know, that the matter has just been provisionally withdrawn.
And you further indicate that at that meeting, Advocate Mokgoro once again said he was waiting for evidence and that he would reinstate it once that evidence would come.
Yes, it was a question of when I'm finished with the evidence that I require, then the matter will be good to go for prosecution purposes.
You were not aware at that stage that Mr. Dramat General Dramat had asked for the matter to be reviewed?
No, he did, well, no. it would not accord with his letter, because in his letter he was just concerned that the matter has been withdrawn. So as counterparts, obviously, we talk to each other, we telephone each other, we write to each other sometimes. So he was just concerned the matter is withdrawn. But then we assured him that no, the matter is provisionally withdrawn.
Right. And at any stage was your advice sought in respect of the involvement of the Inspector General in the Mluli matter?
Now, it wouldn't be my place to advise on that. So I was not asked.
Okay, you were then shown a Exco minute meet.
I don't understand that. Why would it not be in your place? If a legal opinion is being voiced and your opinion as a leader would be then be sought?
No, I'm talking in terms of the operations, where the prosecutor would say, this is what I want, this is who I want to deal with these aspects. So I would not be privy to, firstly, the case, but if the brief was coming to me to provide a legal opinion on whether or not this case would warrant an Inspector General, then that would be my brief. But then in the normal course of events where prosecutions are being conducted or investigations are being conducted, I would not be part to those activities. It's not my place to be part of those activities.
Your recollection of the minutes of the 24th and 25th January 2012, which was shown to you, was that there was an agreement. There was agreement as to what in consultation meant in the context of the NPA Act.
Yes.
Right. You were asked to do a confirmatory affidavit in respect of the affidavit which Advocate Jiba filed in the GCB matter. What transpired in relation thereto?
Well, Advocate Jiba, at some point before, I take it's before she deposed to her answering affidavit in those papers, approached me and asked if I would be amenable to putting up a confirmatory affidavit for her. I said, yes, I will do that. And we spoke about, how the FUL matter was handled, my involvement in it, and I repeated, the stance that we took, etc., and that's where we parted. And I was never asked again to depose to any confirmatory affidavit or finished with one, or even Advocate Jiba's answering affidavit in the GCB matter. So it ended there. So I thought maybe she doesn't need it anymore, because even for me, I was like, but this matter, if what has been, what is the issue? Is the issue that we dealt with it in the fashion that we did, that we got the NDPP not to talk about, the decisions of the DPPs. What is it exactly? So, yeah, that's how I took it.
You don't remember the date of that conversation?
No, I don't. I didn't jot it down. I didn't put it in the diary.
Black book is not used for conversations.
Yeah, there's been many times that we visit each other's offices. We wouldn't record such things. We're just working. We are working.
You were shown the Exco minutes of 5 March 2014. That relates to a meeting under Mr. Ngaksana in which he raised the question of the Boyson matter in the media and the status of the matter. Do you recall that?
Yes.
And it was at that meeting where it was said that Advocate Chaki would provide a report. Do you remember that?
Yes.
And Advocate Jiba informed Mr. Ngaksana that that would be the case.
Yes.
Right. You made it quite clear that this was a matter being dealt with by the organized crime unit and not LAD.
Yes.
Right. And you were then informed that Mr. Chita was involved in that matter.
The
Oh,
Boyson matter.
yes. No, sorry.
No, I don't.
No,
think
I've
it
got
was-
cases mixed up, sorry. No, take that
Yeah,
question
no,
back.
We didn't deal with the matter.
Yeah.
Totally.
And you've never seen or have no knowledge of whether a report had actually been provided?
No, I wouldn't know, because then it was asked for by the NDPP. It was not asked for by EXCO. So-
But it stays on the action log of the matters emanating from those meetings. So presumably it would have to be reported to the EXCO meeting when the action has been completed.
Yeah, it will have to be if it remained on the EXCO action log. But for me, this is the report that is required by the NDPP as to what is it that, that happened in the matter. For his information, because the matter had occurred. LED was not involved. I think there was a pending appeal at the time. I think there was an appeal, or there was the discussion around whether to appeal or not. But if there was an appeal, it was then withdrawn. There was, I was not involved in those aspects.
Now, I want to take you back to paragraph 55 of your affidavit, which we jumped over. And these were relating to the authenticity of emails and documentation which encountered.
55.
It's on page 18 of your affidavit. 55. Paragraph 55.
Yes.
Right. I provided you with a document which is NM1, which appears to be a document to your personal assistant from Palesa Matsi, who's the personal assistant of Advocate Jiba, correct?
Yes.
And it's dated the 12th of July 2012,
Yes.
right? And what are your comments in respect thereof? Have you checked the black book?
No, it's one of the colored books here.
Ah, okay.
Yes. At first when we looked at this document, we thought, no, we have not received it, more so because we were shown some documents by the evidence leaders which were attached to what I needed to comment on, and then we picked up that some documents are either not in existence or they've been spoofed as the emails. That's the IT language. I'm not an IT guru, but they were spoofed emails. Then my PA picked up the bottom page of NM1. At the bottom, the date, she picked up that it's not even written that the 12th of July, there's a Q, and what is that? So she started questioning that. But I said, let's go to the incoming book and see if you've received, this thing. So we found there in the incoming book for July that there is an entry for the 12th of July 2012, which relates to the FUL matter, and it has reference to Rule 30A notice. And there, it was then booked out to Peter.
And what did you find strange about the memo in itself? Would the NDPP receive such a thing from your officers to comment on? Or from LAD?
Well, in the normal course of events, it would then be us compiling something for the office of the NDPP, even if it was going to be the NDPP's response at the end of the day. On a technical thing like a Rule 30A, we wouldn't want the NDPP to be bogged down with these technical things, small things. But then, yeah, this is there's an entry of a Rule 30 notice booked out to Peter on the 12th of July 2012.
You then also got referred to certain emails by us, correct, which is Annex to NM2.
Yes, and this is not all of it. I just didn't want to put up everything and just burden the affidavit for unnecessarily.
Right. And these are emails which we indicated to you were provided to Justice Yaqub.
Yes, you said that.
And if one looks at the email in the middle of the page where your name appears, one will see that the email address is actually not yours. Is that correct?
You're referring to NM2, right?
First page of NM2. I had sent you an email which says,
Or
that-
we're starting at the top?
well, the top is our communication of NM2, the first two. So
Yes.
the stuff that is in the middle is the stuff that was forwarded to you.
Yes.
Right? And essentially, I'm drawing your attention in the middle of the page where your name appears, that the email address there is not your email address. It's a spoofed email.
Yes. And another attention that I want to draw you to is, if you look at the top of the document, the standard format is from, FROM. And then this one, it says FMM, meaning what? There's an R missing, there's an O missing, it's just FMM. And then in the mail address, in brackets there, it has is it NIV?
NIV.
NIVJ or Katla. That's not my email address. But then when there were investigations done on this document, all the recipients of this spoofed email, the email addresses are wrong. It's not the proper email addresses. You'll find a dot when it's not supposed to be there. In some,
Like the Gmail looks like a G and a R,
yes,
and an N as opposed to an M.
yes. So those are the things that we picked up. For me, I picked up, from first time that FMM. This is probably not from me. And then I look at the email address. It's not mine. We went to my emails. I don't have this. We asked IT to go to the back end, to the server now, where all the other documents would have been stored. So they went into there, they uplifted, they compiled what they called a PST, but this is where they took all those documents that come from that time to put them in view for us, and there is nothing of this sort. There's no email from me on this date, this time. No.
So essentially an external IT person came in, downloaded all the backups from the IT server, put it onto your computer, you searched, and these emails were not found.
They were not found.
Right. And that's how the conclusion was reached that these were fake emails.
Yes. And then if I may draw the attention of the commission to the bottom page, the bottom page, or the bottom of NM2, sorry, the email address is there as well. They are spoofed. There's also a Jackie Lipinka. It's not a proper address there. And then again, it's an email that is now sent on the 28th of June, 2013 at 4:21 p.m. It says here it's supposed to be from Terry Mutau. You can even see the name of Terry. There's an apostrophe before a Y.
And Nokwe is wrong there.
Yes.
Yes. But if you turn the page to page 33,
Yes.
and you look in the middle of the page, the email exchange between Jackie Lipinka and Terry Matau, those email addresses look correct. That is Ms. Lipinka's address.
It will seem like that, but she will have to confirm as well, or maybe someone from IT to confirm. But what perturbs me is that I don't know if this is how the documents were scanned, because then I don't know whether it's the trailing email or what is it, but if it's supposed to be a trailing email, the other recipients are not showing on the document. It's only Jackie Lipinka to Mutau, and then the other one is from Mutau to Jackie Lipinka, and the dates is the 26th of June. Both of them are 26th of June. And they seem to be talking about what? The FUL matter? We will assume that. I don't know if they were talking about that, but this is the time when Terry was on brief. So Jackie Lipinka was in the office of working, from the office of the acting NDPP at the time. So I wouldn't know if she had instructions to communicate with Advocate Mutau or what, but we would not frown upon it because she's in the office of the NDPP.
So the bottom email, which is at 2:25, shows Matau sends an email to Jackie Lipinka and Andrew Chowki. The subject matter is a draft affidavit, and it says, "Thanks for the enlightenment this morning. Please receive here what is discussed." So it seems to be pursuant to a conversation, and then the email above is an acknowledgement of receipt by Mr. Pinka.
Yes,
That's what it, on the face of it, appears to be.
yes.
Okay. Were you at any stage finally party to a briefing of Advocate Jiba in the full matter, or solicited a memorandum for purposes of briefing Advocate Jiba?
The first memo that we sent out to the state attorney when we were briefing Advocate Mutimele and Tim, yes.
And subsequent to that?
I have not briefed anybody subsequent to that in relation to the FUL matter.
And did you provide Advocate Jiba personally, or was asked to provide any progress reports?
No.
Okay. Thank you. I've got no further questions.
Can I just get a feel of the impact of all these occurrences? Now, all that you're talking about, what I may, for lack of a better word, call a fake correspondence, your involvement, your apparent involvement in occurrences where you were actually not involved, where you were named in unsigned documents which give the impression that you were part of the compilation of documents. These are definitely not normal occurrences in a normal working environment. Okay. Now, how did you process all of these occurrences in your own mind, in your working situation?
For me,
Did you express the impact of these occurrences, or how did these occurrences impact on your work and your working relationship with your colleagues? Just how did you deal with not only these occurrences, but the impact of these occurrences on your work and on the working environment? I just need to get a feel of the impact of all of these things in the working environment in which you operated, from your perspective.
Chairperson, when a story unfolds, you will have information at a particular time and make your decision based on that information at that time. Now that we are here with the commission, in front of the commission,
In front of the inquiry.
in front of the inquiry,
Thank you.
when the evidence leaders give me this information, and first of all, the unsigned, the memos that do not accord with the style that we follow at NPA, the spoofed emails with the dates around the days that I'm working on the matter, I question as well as to why are these things happening, or why did they happen. Now I'm told, Chairperson, that these are documents which were furnished to the Yakub, I don't know, what is it, Enquiry? The fact-finding exercise. And this had occurred a long time ago. I'm not sure about the year. But Zek Yakub was asked to assist us, especially around the issues of the leak of information at the NPA, etc. Now, if those documents were there at that time, why would they be there? Why would we have somebody spoofing emails in my name? For what reason? So it perturbs me, and it has certainly impacted very negatively on our work, albeit that some of the information I will only know now as we are coming to the Commission. As at the time the FUL matter was being dealt with, I was not aware of certain events, as I've already testified, that my first involvement, I know we need to brief outside counsel. I facilitated that. Outside counsel is briefed. They go with the brief. It's in accordance with my instructions. I leave them to deal with it. They draft answering affidavits. They are brought to me. I settle them. I send them back. I'm thinking all the process need to now be complied with, because then it has to go back to the NDPP to settle it and sign it, because how do you then file an affidavit without the deponent signing it? There's a state attorney involved, 2 silks, there's a senior advocate from the bar, there's also Twitter. So it comes now to my knowledge the following year that there hasn't been any filing of any answering affidavits up to June. And then I come at a time where things have gone pear-shaped. Filing was supposed to have happened on the Monday of the 24th. I get to know about the matter on the either 24th or the 25th. I try to do my best to make sure that there is filing. We need to comply. There is a matter that is before court. There's already been the DJP's directives that you must file by so many, such and such and such and such and such a date. So the dates of the 24th of June emanated from that, as I understand. But then we are late in any event, because I still have to wait for Advocate Mokgwebi's input into his affidavit, because this is his involvement that is complained about. He's the real person for us in this matter. Advocate Chauke's matter was simply that there is going to be an inquest, and I'm provisionally withdrawing the matters from the roll so that all matters are heard one time. I don't want to have piecemeal trials, because then some of the evidence that I need is contingent upon the findings at the inquest. So that was understood. The issue was now with Advocate Mokgwebi's affidavit, which we needed to make sure and to take care that it deals with the aspects as they're supposed to be dealt with. So this is now what we're waiting for. It comes when, on the 25th, in the evening of the 25th of June, the date of filing is the previous day. At the time, Madam Chair, obviously I feel aggrieved. Firstly, I was not in the loop of things that the answering affidavits have not been filed. There has not been any further progress that have been given to me. To my mind, I'm thinking perhaps the FUL has abandoned its application, or they simply have not filed anything. It was just a matter of maybe one of the parties setting the matter down. But they are the ones, they are the applicants, they must now, kick the ball and put the matter on the roll. But I was not happy, because then I could see that I was not kept in the loop with all the necessary information. But then at the time that you find out, the horse has already bolted. If there is a complaint that you've withdrawn a matter without consulting with the DPP, and that has already happened, it has already happened. There is nothing further I can do. if I am told there is no review in front of my desk, there's no review that I have to deal with, I take it that there is no review. That is why I will take that stance and advise you and say to you, there's no involvement from your office, therefore keep yourself out of it. Don't even touch anything. Let the people who made the decisions be the ones who put up affidavits. This is me protecting the office of the NDPP. Now, if I find that there was a review application, if there was and I was not told, then I feel aggrieved, because then it has already now shown the impact that it will impact negatively on the work. It impacts negatively also on my integrity, because how do I then give you an advice that is contrary to the information that is placed before me? How do I, and consistently the office of the NDPP needs to be kept clean from all the operational issues and all the operational decisions of the DPPs. It should only come to the NDPP where there has been a violation or a transgression of prosecution policy, which is serious in nature, that it warrants the attention of the NDPP to move the matter into her office. Where there is a Section 179 review where she now has to consider whether or not the charges or the case was properly withdrawn, or that the prosecution needs to properly proceed. So for me, it's my personal feeling that when you are not given full information, obviously, whatever decisions you make are not going to be proper, or a lack of better words, I will use proper. Because even when you place a matter before court, if you're not placing all the facts that are going to assist the judge to give you, a relief, you will not get it, because you've not placed all the evidence, all the relevant evidence before the relevant person who's supposed to then make a decision out of that. So this is what I'm feeling. So at the time, when the NDPP briefs whoever they want to brief within the office of LAD, it was not taken as something that is not supposed to happen. We are all officers of the court. We are all, there to assist the NDPP. So if the NDPP wants something from either Gerard Nel or Tobile, it is well within her rights to be seeking any assistance from any member of the prosecution authority without worrying about the rank, etc. But where the law warrants you to do it in a particular manner, you then shall do it that way. Hence, there's an issue around the in consultation or the after consultation. There, it is in terms of the law that the DPP and the special director must do things in consultation when they decide to proceed or not to proceed with the prosecution. But in the other matters, there is nothing untoward. But if you are appointed to render support in particular aspects, especially in the civil aspects, and you are not kept in the loop, and you are flighted as the head of legal affairs, then it will pain you, of course, that you've not been kept abreast of certain, events. So for me, it was important that at least the state must make sure that they don't mess up, as it was out there that just rely on the state to mess up your case. Those are utterances that were coming out from there, that you can always rely on the state to lack of better words, mess up again cases or lose money unnecessarily because we don't sit and consider cases properly. We're just branded as that. So it was important for me that at least where I am at the NPA, that we should file papers on time and that we should do our utmost best professionally so to render proper advice to the NDPP.
In other words, you work with what you have and you just do the best you can
Yes.
under the circumstances.
Yes,
Thank you.
Chairperson.
Examination, who starts?
Yes, thank you.
Okay. Mr. Masuku, thank you.
Thank you, Madam Chair. Advocate Mohatla, I just want to take you to the evidence you just gave now, right at the end of your, when Justice Mokgoro asked you a question and you referred to the fact that you felt that you were not kept in the loop. Am I correct?
Yes.
And that, or if we were kept in the loop, and I'll come back to that, and when you were kept in the loop, you were not given a complete picture. When you were kept in the loop, you were not given a complete picture of what the facts are, and you gave advice on the basis of the facts that had been given to you.
Yes.
You trusted the facts that were given to you.
I had no reason to distrust.
Right. So you gave good advice. Just to confirm this, my client, Advocate Chiba, confirms that she received very good legal advice from you, and that she always found that you're ready to assist her office to take on things and to get things moving. But coming back to, I was not kept on in the loop allegation, who do you suggest should have kept you in the loop? You were the head of the LAD.
Yes.
So who was supposed to keep you in the loop?
Like I'm saying, the documents that are now being furnished to me, if you were listening to me, that I now find that there are certain occurrences according to these documents which I questioned the authenticity of.
I understand that.
Number one, that certain events occurred, but some of them have been confirmed that they indeed have occurred. Halcrain was in the loop, was on brief. The memo, especially the memo of Glenis Breitenbach, which is, according to the evidence that was given in this inquiry, that the memo is in existence. The memo was indeed given to the office of the NDPP, and
Let me put it this way.
and again, the matter where I am now apprised that the matter at the time was provisionally withdrawn, but inconsistent with what then was shown to me, which I saw, which is the Glenis Breitenbach's disciplinary transcript, where, if I'm not mistaken, is the transcript or the memo where Advocate Mokgoro had said to Advocate Mzinyati that he was functus officio, he's made his decision, That's what I'm referring to.
Okay, I understand.
That at the time I was given instructions, at the time I was making inquiries for purposes of advising Advocate Jiba, I knew that the matter is provisionally withdrawn. Glenis is sent out to go look for evidence, and she doesn't come back with the evidence. Instead, when the 2-week period is about to end, or even before the 2-week period ends, then we are slapped with an FUL application, which is something I said I frowned upon, because then why would an outside party come and file an application against the NDPP when the matter is still being dealt with?
Let's put it this way. At some point, you occupied dual roles. You were the head of the SIU, and you were also head of LED.
Indeed.
There was then a discussion between yourself and Advocate Jiba on how you would manage both roles.
Not both roles, just about
The LAD, how you would be available for the LAD.
about her needs as the NDPP when she requires support from LAD.
So there was that discussion. That's what I'm saying.
Indeed, we had
Right.
that. We had to have it, because then I was not always there for my NDPP.
Yes. So that discussion resulted in the two of you agreeing on how you would operate, how you would engage your services or the service of LED to assist the acting NDPP at the time, right?
We talked about a liaison person. I would
Yes.
not bog her down with the details as to, okay, you'll phone, you'll email, you'll do
No,
this.
because that you did anyway. With her, you had that
Yeah,
other
we
relationship
talked
with her.
about the person that will be the go-to for her.
And-
In
and
my
the-
absence,
You agreed on Mr. Krita.
yes.
Yes. So Mr. Krita basically stood in your position, in your place. She could go to Mr. Krita anytime, and she would assume that when she has spoken to Mr. Krita and she has received whatever advice she has received from Mr. Krita, that advice is from the office of the LAD.
No, she would not assume that because there were times when we would talk. We would talk about it. This is the highest office within the NPA. You are not going to rely on somebody when you've given me a brief as the deputy national who's supposed to support you. So I'm saying this because we were talking about this case.
No, but what I'm saying is, in terms of the arrangement, look, I'm not fighting with you, so don't
I'm not
take...
fighting.
Yeah,
You said
so
assume. I
let's-
cannot assume on her
No,
behalf,
but-
and I'm
but
saying
it-
to you that
Can I finish the question?
assume. She cannot assume
Can
that.
I finish the question so that you can answer, answer
Okay,
it
you're
well?
asking another question.
No, let me ask the question. I'm asking the question, you're answering. So let me ask the question. The question I asked you was, you had made an arrangement with Advocate Chiba that you'll have a liaison person, and that person was Advocate Klita.
Mr.
Or
Klita.
Mr. Klita.
He's an attorney. He's
Yes,
very particular.
so it was Mr. Klita,
Yes.
right? So Mr. Klita was going to stand in your place. Am I correct or am I wrong?
Not stand in my place as a deputy national.
No,
This is
I
a
understand.
person- This is the person that Advocate Jiba, when she needs something and she can't reach me, she will go to Trita and say, this is what I need. Trita will then come to me. I was not in any way putting my duties on the head of Tobile Trita. Why would there be a need for me to go and consult with the NDPP?
So what you're saying is that the first thing that your agreement with Advocate Chiba was that the first thing she would do if she needed advice from LAD would be to come to you.
No, not advice. Anything that she needs from me,
Yes,
she will do that through Trita.
right.
If she
So-
cannot reach me on the phone,
from what you said, is the agreement that she will first try and find you on the phone.
yeah, there's phone, there's email.
So she
There
will firstly
are
find.
many ways of trying to get hold of a person.
Okay, just let's be general. So she will try and first find you,
Of course,
and if she cannot find you, then she would find Klita.
of course.
So the agreement between the two of you was that you will always be available. If you're not available, then Klita will take over.
Yes, but then the always available, remember I was now occupying another office. There will be times when I'm in meetings where I cannot be disturbed, or I'm making briefings to Parliament, of which I'm not going to be able to answer to any requests directly or immediately for the NDPP at the time. So if there's anything civil and legal in nature that requires court or whatever time as filing, here is a person that you will go to, and at least you are assured that I will get to be apprised about it. And that was how we worked, and that's how it should be.
So that's how I understood the evidence. I didn't understand your evidence to be that the first line of call for Advocate Chiba when she needs assistance from the LAD would be to come to you. In terms of the arrangement, you had provided a person who was readily available all the time, who was at the beck and call of the NDPP if she needed needed any assistance from the LAD. That's how I understood the advice.
Okay.
So I mean, so we agree that there was an outstanding arrangement that Klita would be available to assist, and what Klita would then do, if there was a matter, he would then come to you, either brief you or seek advice. Am I misrepresenting the agreement?
No, he would definitely seek advice in some things that I would send him, but he understands in terms of protocol as to what decisions he can stop at.
Yes, so I understand that. So you would be appraised of what's going on in any matter by Klita.
Yes, and he would not move any step further if now this step requires a higher
Authority.
authority.
Yes, and you would be that authority.
That is understood. Everyone understands that
Right.
within the NPA.
Now, so Advocate Jivas accepts that. She agrees with you that there was Klita who was always available for her. She would ask her to look at cases and to give the office the advice. And if she did not like the advice, she would call you. And she'd say, no, what's going on here? Because I'm not getting, proper advice on this, or can I understand, is this what you guys are saying I should do?
Did
She would
say-
only call you when she was not happy.
Are you saying she said that, or is that
I'm
what
putting to
are-
you that that's what she instructs me to say to you.
Oh, well, that's what she said to you.
Yeah, but I want your comment on it.
What do I say? If she says, I received something and I wasn't happy with it, and I called Mokgatla to...
No, you see, I would have, my cross-examination would have taken 5 minutes, actually. But you
You're
appear
not
to...
putting your questions right then.
You appear
Ms.
to be...
Mokga-
You appear to
Advocate-
be...
Advocate Mokgatla, just kindly respond to the question, answer the question.
Thank you, Chair.
And
what,
as long as Mr. Masuku asks the question directly, simply, so that you get the responses that you're looking for, kindly answer the question. Don't ask him questions.
Can I proceed?
Can proceed.
Thank you. So all I wanted to have on the record is a very clear understanding of how you and Advocate Jiba decided to work together. That's all I really wanted. I wanted just that clarity to be absolutely clear that between yourself and Advocate Jiba was an agreement that Mr. Krita would be the person that she would go to. She needed to be helped even in your absence, and that she could in fact call on you if she felt that she needed you to come and provide further assistance. That's really all I wanted.
Okay. So there are layers of work within the NPA and to support the NDPP, right? As the head of legal affairs, obviously, the final say will be then with me and discuss that with Advocate Jiba then. If Advocate Jiba is happy, she will be happy. If she's not happy, she's not happy. The final buck stops with her, right? So I did not, in giving Mr. Krita to Advocate Jiba, that I am, delegating my duties to Krita.
No,
This
that's-
was in relation to making sure that proper messages are relayed and on time, that if there's anything that needs to be done for court purposes, because then we have the backup of the state attorney. And in the matters that are on the table, there is counsel who is involved. So that is the role of advocate, of Mr. Krita, not to say he must then render legal advice to the NDPP. So I wanted to be clear that when you say this is a person who will assist you in my absence, that I am saying he will be performing the duties of a deputy national. For any other matters, we had a way of working within the LAD that for legal opinions, this is where you'll go, this is where you'll go, this is where you'll go. But then there will be those things which are very quick in nature that you need these things to be dispatched. You need him to stay awake maybe in the night, make sure that you get Mokgatla on the phone. This is what I need. That's what I'm talking about. And if you understand me, please indicate. If you don't, I'll explain further for you.
Sorry, I do understand. And of course, when you're complaining about not being kept in the loop, you're not suggesting that the person who ought to have kept you in the loop is Advocate Jiba?
Well, judging from the documents that have been given, if a person says, I have given Advocate Jiba this, and it's not disputed, and she admits I've received this, and I had specifically asked the question as to whether there's anything relating to this matter on your desk, and she says, I don't have it, I accept that. But if I find that it had happened, then she has not kept me in the loop.
Sorry,
And
did you hear my question? Can I repeat it?
No, you're saying, am I suggesting that who was supposed to keep me in the loop?
Yes.
So I'm saying that being not kept in the loop is evidenced by what is coming out now, that I was not kept abreast of everything in the matter. Now, I have been given documents, there has been events, some of them confirmed, some of them unconfirmed. I'm given documents that don't have signatures and what have you. So what I'm saying, if you go by what is put before me, I was not kept in the loop. And then it means then Advocate Jiba did not keep me in the loop when she said, I have nothing on my table, and if there was something on the table. Krita would be the person who has not kept me in the loop if that was the case. Now, there are briefings to council, which I was not involved in, which I see there are documents which purport to be memos to the CEO that please brief this person has done this to us and what have you, in the hand of Mr. Krita, if that is him. He is the one who has not kept me in the loop. There are progress reports that are written here, which I question the authenticity of to start with. And in the progress reports, there are certain things, others are confirmed, others are not confirmed, others are not kept in the loop. Now, if Krita is the author of these documents, he has not kept me in the loop. So in respect of the FUL matter, it will be 2 people, 3 people who have not kept me properly in the loop. It will be Advocate Mokgoro, it will be Advocate Jiba, it will be Mr. Krita. That's what I'm talking about.
Yes, so your answer to my question is that your expectation was that Advocate Jiba would keep you in the loop.
Around the material factors, where I've also posed direct questions, do you have anything on your table?
Right.
Nothing. No review,
Maybe-
no representation, yes, nothing.
Yes, because that's your big complaint, that you were given certain facts which in your view turned out to be wrong. You gave your advice on the basis of those facts, and it now turns out, looking at these papers now, that that was not true. Let me put it this way to you.
If it is true, because I'm saying to you, if you are listening, I am
No,
questioning.
ma'am, can
I am
we
questioning.
just be polite to each other? Because
I'm not
let's be
in
polite
any
to
way
each
being
other.
saying-
disrespectful.
Can you
Yes.
just
Yeah.
let her answer?
Because I do think that when you say if I'm listening to you, you're assuming that I'm not. I am listening to you.
But
I am listening to you.
I did say that these memos that are being given to me are unsigned. If we were to go by that they are true, that's what I said. That's why I'm saying if you were listening. You get what I mean? I get this memo which says 1, 2, 3, which is something I was not even privy to
Sorry.
at that time.
Which memo are you talking about, ma'am?
I'm talking about the memo of the 16th of May 2013. I'm talking about the memo of the 25th
Okay,
of
no,
July.
let's go with the first one.
2013.
Let's go with the first one. What memo are you talking about? The 16th of,
16th of May, which was
Who is it
which
addressed to?
on page 52. It's to Jiba.
right. So
And
Advocate Jiba did not write the memorandum. You
No,
understand
she
that?
did
She
not.
didn't.
Exactly.
Right.
And it's unsigned. This
yes.
is the document that I questioned.
We understand that.
Yes.
But she did not write the memo.
No, she did not.
So I don't understand
No, I'm
why
talk-
you're citing that memorandum as a basis of your expectation to be,
No, it's
to
not
be,
just-
to be, just let me finish. As a basis of your expectation to be appraised or to be kept in the loop by Advocate Jiba.
No, it's everything else.
No, you cited the memo of the 16th of May. I'm putting to
As
you,
an
ma'am, that,
example.
yeah, but what expectation did you expect there from Advocate Jiba on that memorandum?
The memo of the 16th.
Yes.
But the memo of the 16th of June.
Yes. No, the memo that you cited now, the one that you just
No,
referred to.
I was giving you examples of documents that have been shown to me.
So,
That if we go by these documents, which I'm questioning the authenticity of, if we were to go by these documents, then I would say, number 1, Tobile Krita did not keep me in the loop. Number 2, Advocate Jiba then did not keep me in the loop.
I'm interested in Advocate
On the
Advocate Jiba,
Let's
and
talk
that's why
about
I'm
that
asking
one.
you.
I'm talking now about the memo. This memo, I think it's the memo of Glenis
The-
Breitenbach
I will
and
come to that.
Ferreira.
Can we
That is
park
the
that?
one I'm talking about.
Can we park that for a moment?
Yes.
Let's go back to the memo that you referred, the 16th of May memo. What is your expectation of Advocate Jiba in that memo? What is it that she should have kept you in the loop on regarding that memo?
No, I'm saying the memo of the 16th of May. I question this memo. So I'm not going to be expecting anything from Advocate Jiba in relation to this one.
Okay, let's go to the Breitenbach memo.
From Advocate Jiba, I would have expected then to be apprised that there is an existence of a query on her desk relating the Mluli matter, which comes from Glenis Breitenbach.
You remember?
There's a review on her desk in relation to the Mluli matter. To that, I didn't ask about the memo because I didn't even know about the existence of the memo. Now, if it is taken that the memo was in front of the NDPP and I was apprised that there is this memo, what is it complaining about? What are the issues in the memo? What is it purporting to do? What attention is required from the NDPP? Because then I would say, in opposing the FUL application, that in fact there is something that is still being dealt with in the office of the NDPP. I'm talking in that regard, because then the application would still, in my view, be premature, because the NDPP has not been given an opportunity to address the query that is on her desk. So I'm saying if then the memo was on her desk at the time, then she did not, and the memo was really in front of her, it was on her desk, as in the office of the NDPP, and didn't tell me about it, then she did not keep me in the loop.
Let me tell you what her recollection of the meeting you had with her on the FUL matter was, which you gave a good advice, which she took and she used. In the issue in that meeting was about FUL. It was whether or not FUL was at that time entitled to seek to review decisions that had been taken by particular prosecutors. Am I correct?
When we were dealing with the FUL matter.
You're dealing with the
matter-
FUL. When you had the meeting with her, you were dealing with the FUL matter.
Yes.
And the issue in that matter, the advice you gave her was correct, which was that FUL has not presented any, it has not made any representations. It's not, in fact, my learned colleague even said, it's a principle of exhausting internal remedies.
Yes, in terms of
So,
the law.
I mean, why would she have told you about a memorandum from Breitenbach? What relevance was it, did it have to the advice you gave her on the FUL's failure to either make representations or to exhaust internal remedies before they review a decision?
No, it would be to the content now of her affidavit. Because I advised that, okay, you can talk about only the law and the process and policy directives. But if the memo was present, then I would have said, you will then say, I have this matter on my table. There's a query that I am addressing, which I'm not done yet with that. So the application, the FUL application, in my view, would still be premature. I'm still dealing with this matter. So I didn't say to her, say you are still busy with this case.
So just so I understand your problem with the fact that you're not told about the Glenister document, the Glenis document. Is your feeling that that document was deliberately withdrawn from you, was deliberately withheld from you, so as to solicit advice that was convenient?
No, that's not my thinking. I
So, but
didn't think
can I-
that far, that it's deliberately withdrawn from me.
So I don't understand.
I'm saying to you, if this document is in front of the NDPP, and this will be material information for purposes of opposing the application. If that memo was there, my advice would then be, okay, give me that memo, let me read it, what is it that it requires from you? In any event, even if that memo existed, I would say, okay, in your affidavit, you will simply mention this aspect. I am still dealing with this matter. You are too far ahead of yourselves.
So you are not saying that there was a deliberate attempt by Advocate Chiba to withhold critical information from you, so that from you in giving the advice that you gave?
I'm not saying that.
Okay. Then, now we've established that the person that you gave to Chiba, that's your word, person you gave to Chiba for whenever she needed LAD to assist.
Me.
Yes.
Not LAD. There are many aspects.
No, but we're talking about Mr. Krita.
Yes.
Yes.
It's
That's the
when-
person.
Yeah, she needs me.
Yes.
not necessarily LAD. LAD is a component, and there are many services that are rendered from LAD. So for other purposes within LAD, you know, your vetting of contracts, etc., I would not be even involved. The files will come to LAD. My PA will send it to the central allocation place, and then they will be booked out, and then they will deal with them. Unless there's a problematic area of law that I need to be involved in, then I would come in.
It's just, I just wanted to talk about Krita. That's really all I wanted
Yes,
to talk
that's
about.
why I'm making a distinction between
so, I
LAD
mean,
and me.
Yes, so, but you understand that you're the head of the LAD, and
Yeah.
the arrangement you have made is that when Advocate Jiba wants to deal with civil matters, she will deal with Krita if you are not available.
When she needs me, she will then go to Krita. There's a difference. That's why I'm.
Sorry, what is the difference?
The difference is if she needs me, she needs me. I always come to the office. As I said earlier, I do half day here, half day, or including the night, either office. So if there's anything that is urgent that requires my attention, here is this person. My attention, here is the person for you. Not that civil matters go to Krita. Because
So-
there are other people within the LAD who are dealing with civil matters. It's not only Krita who's dealing with civil matters.
So if, when you say if she needs you, are you saying she would need you for any other purpose other than for any other purpose other than the professional role that you play as head of LAD?
No, for any other matter that she may call me to fulfill for her, that is within the mandate of the NPA, yes.
So she would come
because
to
we
you.
are there to support the NDPP. We are given portfolios to run, yes. But it doesn't preclude her from asking me about civil matters, for instance, that may emanate from the asset forfeiture, because then it will be something that is still within, you know, my mandate to look at civil applications. So that's what I'm saying.
So you really, am I wrong to say that Mr. Krita was your eyes and ears on matters that Advocate Jiba, or matters that were referred to, civil matters that were referred to the LAD in which the NDPP was involved?
In some of the matters,
She was
not-
your eyes and ears.
in some of the matters.
Yes.
Everybody who was dealing with civil matters was my eyes and ears. in
I just
relation
asked
to-
about Krita.
Yeah.
That's all I wanted.
No, I just
Krita.
don't want you to make it like it was only Krita. There
Yes.
were other people as well who were fulfilling their roles.
But the person
Just like him, yes.
Just-
But then as a person that she, if for some reason or the other I am unreachable, then she will then relay it to Krita.
Now, would I be correct to say that it appears that Krita didn't really give you briefings on what was going on in some matters?
Yes,
She was not doing that.
yes.
And is it something that you discovered recently?
As in recent, you mean? when?
Recently when you consulted with the evidence leaders?
No, I could pick up even earlier than that, yes.
Earlier than that?
Yes, but I
And-
was asked in respect of the FUL matter.
Yes. So, and when that happened, when you discovered that Mr. Krita wasn't really giving you any feedback or giving you directions on, or just giving you, information on what was going on, what did you do? Did you take measures as her boss? Did you speak to Jiba about it and say, well, it looks like here, Krita is not telling me and giving me the full story of what's going on here. Can I understand, is this what you and Krita have been doing, or did you take any measures to correct that kind of a system?
The memos that alerted me to the material aspects in this case have been given to me by the evidence leaders. And I didn't know about the seeking of approval to brief certain counsel in these matters, that other consultations have occurred, that Advocate Jiba had attended some of the consultations at chambers.
Sorry. Sorry, Advocate. Are you saying that the first time you got to know that there were advocates, different advocates, were briefed in one matter, is something that you got to know when you were, when you consulted with the evidence leaders?
No, I'm saying at the time when Mutau, let's talk about the FUL application. At the time when Mutau was on brief, I don't know who briefed him, what time and for, and what documents were given to him. I get to know when a document answering affidavits had to be filed by the 24th.
I understand that.
Yes.
And that,
So I got to know that time that, okay, there's this set of advocates which has been briefed, and I was not party to that. But I did not take any disciplinary action against anybody at the time. My main mission was to make sure that answering affidavits are filed.
okay.
We are already out of time here. I'm at pains to even try to put up a condonation application, which I had to painfully abandon because I was not getting information coming from the previous year into June of 2013. Why were these things not done? But that is not the time to be saying, you did this, you didn't do this, you are supposed to do this. We need to be dealing with this matter right now. This is the animal that is facing us now.
Subsequent. Didn't know.
The NPA protocol, there is no one who can brief counsel without the approval of the NDPP in matters that relate to the NDPP and without the approval of the CEO. So if you is not just there for the sake of being counsel. Counsel need to do what they are supposed to do. The state attorney is there too. Times for filing, etc. They need to make sure that that is the case. So I also understood that Advocate Jiba wanted outside counsel. And at some point I remember saying to the SIU people that, no, this is a matter that I can just go to court and get the NDPP out of this mess because she is not supposed to be cited as a party.
I'm just putting it out there that, I mean, if I knew I'd just circled a very important affidavit, or I'd made a contribution to an important affidavit, and I had nothing of that affidavit later on, especially from what you say, after making a contribution to the affidavit, you gave it to, and you asked the messenger to take it to
Advocate Jiba's office.
Advocate Jiba's office. I would have followed up to find out message. paragraph
Page 9.
page 9 of paragraph 31.1.
Point at the top. At the top.
31.3. 31.3, I apologize.
Okay.
You got it?
The bottom, yes.
Yes. There you say, Advocate Jiba would sometimes engage the assistance of persons employed in LAD without any consultation with me. My absence from LAD could well be the reason for her doing so. I recall also that I had discussed with Advocate Jiba the practicalities of who to appoint from LAD to assist in my absence. Mr. Peter, and we both agreed appropriate liaison between us. Time to time, Peter will then bring documents to me at the SIU for consideration. Though not consulted at times, I expected to be informed of all matters and steps taken, but as I came to discover in relation to both freedom under the law and poison matters, this was not the case. But we had to listen to what was going on the case, that you did not do that.
You see, with the developments that are, council being briefed, debriefed, debriefed, the existence of certain documents, yes, I would say, keep me in the loop. He was supposed to keep me in the loop, especially if it's material that I need to know about it, that it warrants my attention. And mind you, Krita is no ordinary, he's qualified, he's a civil practitioner, he was an attorney in his own right. He came from asset forfeiture, which deals with civil matters, the civil law principles. That is even the reason why I was comfortable that this is the right person as a go-between, because he will understand what the Rule 30A is. Advocate Jiba would not be bogged down with such things, exceptions, this and that, so he would be the person who would understand what the issues are right there and there without having to sit down, read, try to understand what this means. We would be able to converse over the telephone. Is this, an exception kind of a case? What is this? Is it a misjoinder? What is it? Is this, when you talk to your colleague and around a territory that you are all, affair in, you wouldn't be talking about a lot of things. So that is why Tobile Krita was the one, appointed as a go-between, which Advocate Jiba was also comfortable with.
Yes. Maybe before I consider asking other questions, can you go to page 30 of your affidavit?
30.
Yes.
Yes.
There's a paragraph 2 there.
Paragraph 2. 1.2.
No, it's paragraph 2. Just right before your signature, just below, it's above your signature. This is the last paragraph before your signature.
It's supposed to be 83.2.
Yeah, I understand, but just for you to identify it, it's written
Yeah.
paragraph 2. You say that I have read Advocate Jiba's answering affidavit in GCP versus Jiba and others, and deny any allegation contained therein regarding my knowledge or conduct to the extent that it is in conflict with what I have stated above. Do you perhaps have an idea of what it is that what it is that you deny in the affidavit of Jiba in the GCP matter? Have you read that affidavit?
Yep.
Just take us through what you say you deny in that
Is it
affidavit.
part of the bundle as well?
It's not part of the bundle,
It's
but
not, okay. I'll have
you
to
read it
figure-
recently, or did you read it? Did you read it recently, or is it a long time ago?
No, recently, yes.
Yes. Is there something that stands out for you that you could say, the thing that she said here, was what she said in that affidavit that you can recall was not consistent with your recollection of issues?
I'll have to take it out so that I can show you, but it was in relation to the LAD team that advised her. I think it was on the boys in matter, and LAD was not involved. I know that LAD was not involved in the boys in matter. It's a prosecution matter. We did not advise on whether or not the charges so withdrawn against Mdluli, it was a proper, that was what I read.
Perhaps
from-
what would help is if
I'm
we
trying
get
to-
you the affidavit
Yes.
itself so that you can help us with paragraphs.
More so because, for me, I understood the matter to have been provisionally withdrawn, so I could not have advised on the correctness of the withdrawal of the matter. So I don't deal with prosecution, so I was not asked to give any advice on the correctness of the withdrawal of the charges against Mdluli.
So it's in our Dropbox.
Dropbox, okay. Let me see if I have it in my bag. Perhaps I have a hard copy.
Somebody could help with that.
May I, Chairperson?
Yes. Do you have it?
Can you double check your is it 372? If
What
that-
paragraph?
Can you check if it's 372, the affidavit? I don't have the face of it this side, this way.
What would be
They're from
easier for
your
me is
Dropbox.
if you tell me the paragraph, I can go to the affidavit. I'm on the
I
affidavit.
didn't mark them.
Or the paragraphs are on the side of the affidavit.
Okay, I think if these documents are from the Dropbox, it's your 300 and it starts from 372. I'll just have to now find the places. 'Cause at the end, it has Advocate Jiba's signature.
It's fine.
That is the one. Is that the?
I'm trying to get to 372, you say. So which paragraph in that page, on that page?
If you look at page, is it line number 10?
Of which paragraph?
Are we looking at the same document? I'm worried.
It's Advocate Chiba's answering affidavit in the GCP matter.
Paragraph 137,
Right, I'm there.
you are there.
Can you just read it so that is it the one that reads, it was for these reasons that I was uncomfortable with the
Yes.
oral advice furnished to me by Halgren SC team. Indeed, the entire team of representatives from the NPA disagreed with this advice.
Yes, indeed. I don't know Halgren. He came and went without my knowledge, so I would not have had any side of his oral or written advice. So it can never be true that this is the LAD team that has given Advocate Jiba anything in relating to this. So
Just refer me to that paragraph again and show me where the LAD is.
102.
Just show me where, paragraph 137. Just show us where you see LAD team.
No, sorry, not LAD, the entire team of representatives from the NPA. For me, I understood that to be meaning LAD.
But that's not what it says. Just on an ordinary
So-
reading of it.
Okay, but then I did not have any, so that is what I would say, that I was not involved in Halkrein. I have not seen this affidavit. So in respect of that, and Sibele Meta, the letters written, and Hodes and Manaka, I don't know how they came onto the brief. So
I understand
Anything-
all that, ma'am, but what I'm
anything-
asking you is in relation to the paragraph we went on to, with your paragraph 2 on page 30 of your affidavit, where you say you disagree or you deny any allegations contained in the answering affidavit of Chiva regarding my knowledge or conduct, or to the extent that it is in conflict with what I have set out herein. I just asked you to help us identify allegations in Advocate Chiva's affidavit which you say regarding my knowledge,
Yes.
allegations contained in that affidavit regarding my knowledge or conduct, or to the extent that is in conflict with what I've said
Yes.
above.
To me, as I'm saying now, I understood the representatives from NPA to be meaning us, because we are, as LAD, the ones who were assisting her with briefing council, etc., in the FUL matter. So there's talk of Halkrein, there's talk of Hodes and Manaka. It was in relation to that I am saying whatever is inconsistent that has been said here about me, which I felt I'm included in the team of representatives from NPA, of which I was not involved. So
Are you saying that paragraph is incorrect?
insofar it relates to me, but if
But where are you there,
team of representatives from NPA,
ma'am? I mean,
okay,
seriously.
then I don't work there.
Your name is not there.
Is that what you're saying? It should say LAD and not
Your
me.
name, your
To
name
me,
is not. Your name is not
This
there.
is what I'm saying, that's what I understood. That it means that the team of representatives from NPA.
Okay, which
because-
other paragraph do you want to refer us to?
Because then Halkrein, as I said, I was not involved in the Halkrein. I wouldn't know anything about the advice that has come from Halkrein. All right? So
Okay,
it
so
goes
which
down.
other one?
Mr. Give each other a chance to answer. Our record is going to be very bad. Just give each other time to answer.
So which other paragraph would you like to refer us to?
I cannot refer you to particular paragraphs unless you give me time to go through this affidavit, because I made a general statement that where it relates to me, which is inconsistent with what I have said, then
Can I tell you why I would have liked you to tell this panel specifically where in the affidavit of Jiba there are allegations regarding your knowledge or conduct that you disagree with? That's because this matter is a very serious matter.
it is very serious for me too.
And so when you make the allegation that there are allegations in the affidavit of Jiba which says something about your knowledge or your conduct that is in conflict with your reflection of events, that's an important issue for how the panel understands the issues that are raised in the GCP matter. So I mean, it's okay if you don't remember the paragraphs. I can move on.
Okay, but I would need to have an opportunity to go through it, and then I'll point you to 1, 2, 3, and 4. As I said, to start with from 137, when it talks about the NPA, the team of representatives from NPA, and it relates to Halkrein, who has been briefed, who came with an oral advice which was not agreed to. Now, this, with the memo that talks about Halkrein's appointment, then it simply means that Advocate Jiba was also one involved in briefing Halkrein. You get what I mean? So I was not privy to this. I did not brief him. I don't know anything about this oral advice, whether taken or not taken. Hodes and Manaka I only know about at the tail end of the last consultation when the matter is about to be heard. So to me, I understood the team of representatives from NPA to be including me. But we can skip it and then we'll come back to it. I would
Is that the only one that you
really
you
love
can
an
regard?
opportunity to point out to the inquiry for purposes of completeness, so that it does not seem like I'm denying things that I'm not supposed to deny.
But can I put it this way? Can I then maybe make the following statement?
Yes.
That paragraph you have referred us to, firstly, is correct. It is correct as it stands. Advocate Chiba did not misrepresent anything in that paragraph.
I'm not saying she misrepresented
No,
it.
you say to the extent that you're responding to the, as I understand it, your response when you're referring me to paragraph 137,
Yes.
you are trying to show the panel that that's something that corroborates what you say in your statement, which is that you differ with Advocate Chiba insofar as she makes allegations regarding your knowledge or conduct.
Yes. Now,
Right, so I'm saying you pointed out 137
as an example.
as an example. And I'm saying to you that 137 does not, firstly, is not inaccurate. It is absolutely true, what she wrote there. You may feel that you can fit into this entire team of representatives and you want to extricate yourself from it. But she did have people, representatives of the NPA that were with her when she consulted with Halcran. She does not say she was with you.
Okay. If it can be clarified that I am mistaken in believing that I am included in that team,
You
then
are
I will
mistaken, ma'am.
accept. I will accept that because indeed I was not party to that.
Yes.
I will accept that.
And this
yes.
statement is so correct. I mean, it's so correct that the courts have found that it is in fact correct.
Well, for me, as I understood it, it related to me. But if you are saying to me, she says it, she was not referring to me, I'm happy with that. And of course, definitely I was not party to that. So if she excludes me, then that's fine. I agree with you.
And then perhaps the last thing I'm going to ask you, because as I said, I didn't think that we would spend that much time. She says that all civil matters that came to the NPA, whether the NDPP was cited or not, were dealt with through by the LAD. There was not a single case that was not dealt with by the LAD except the one which related to her personally, the GCP matter. That's the matter that she took active interest in, where she appointed attorneys and she appointed counsel. All the others came through the normal routes of LAD, making recommendations to her on what should happen on the case. All of them, including the one that you say you are not aware of, the FUL and the poison matter. They all went through the LAD.
Not all cases would come through LAD.
No,
There are cases
I
that,
mentioned two.
but you started by being general as to that all cases that come to the NPA will
fair
come
enough,
through
yes.
LAD. So I'm saying to you, there will be instances where matters have not come to the LAD. They would have been dealt with at the DPP's offices, which sometimes I made the example that some matters would pick up, they've already been dealt with, but they emanate from the DPP's office. And you know, the state sometimes, attorneys would serve at the state attorney, at the Department of Justice, sometimes serve at the office of the NPA, to the NDPP's office, or maybe in other offices where they would find people to just serve the documents and they will be signed for and be dispatched to the relevant office. So not all matters would come to LAD. They would come in various ways. But in the matters where the NDPP has been cited, there is no way that the matter would be dealt with without the knowledge of the NDPP, without the blessing of the NDPP as well.
I don't think that there would be any matter that relates to the NPA that will not have the NDPP, that would not require the NDPP's interest.
Well, all of them have the NDPP's interest. That's why there are delegations for other personnel to deal with certain
Yes.
matters. And then in terms of the complexity, of course, but where the NDPP is cited, there's no way that it will go out of the office without the eyes of the NDPP.
And so FUL and Boyson went to the LAD. That's what she says.
The Boyson matter, it did not come to LAD.
There are two,
The
okay.
Boyson matter is a criminal prosecution in KZN. It's a criminal prosecution in KZN, and this is where I think there was a review that was served and dealt with in the High Court in KZN. So this KZN has not briefed LAD to deal with the review application on its behalf. I think some counsel was briefed, if there was counsel briefed in that matter. It was dealt with there. We were not party to those proceedings.
Advocate Chiba says that the Boyson matter went through the LAD, the component, the review component of the case.
No. It
That's-
was dealt
that's-
with
that's what she's-
in KZN. We were not engaged in the brief to deal with the Boyson matter.
Can I just take instructions before I? Yes, sorry, just the last question I'm going to ask. I'm asked to inform you that, in fact, LAD prepared memos on the Boyson matter. For the briefing of counsel, they arranged consultations with prosecutors. They basically did the work. It was LAD that did that. The fact that you may not have been aware of it is perhaps because the arrangement you made with Advocate Jiba was that Mr. Krita would be your ears and eyes of the cases that are involved. That's probably the reason why you don't know that.
It could be, but around the Boyson matter, what I remember was that Advocate Mosing, who occupied an office next to mine, was busy with the matter. And
Yes.
in one evening, he came to me, since you brought it up, he came to me and then he said he's busy with an application that is in KZN where they are trying to do certain things. And we discussed, just issues of the law. And I saw that we were not coming to any agreements, but it was not a brief to LAD or anything of that sort. It was just colleagues talking to each other. But I was not involved in the matter. We did not advise in anything. As you say, if it was a memo prepared, it was just for the memo purposes to appoint counsel. It's not to be involved in the merits of the case. So if there was that a briefing, I don't know.
You are not kept in the loop, I understand. Those are questions and cross-examination.
Can I ask one or two questions arising from that? I'm trying to understand. If indeed the LAD was involved in the Boyson's matter, would it have not have come through you to Mosing? Did he not report to you?
Musing was not reporting to me. This is a colleague who occupied an office next to mine. So we sit until very late in the
No,
office.
sorry. So he's not part of LAD.
Not at all. So
He's part of what?
he's in the organized crime section, which reported to the NDPP.
You mentioned earlier that at some stage you were going away. I don't know if it was on leave or you were absent maternity, and you left Krita in charge. Could it be that some of these documents were drafted by Chita while you were away? Or are we talking about different times? And or Chita's involvement as part of the LED or LED could have been during the time when you had gone away.
Oh, I was not away per se. I am still present, but I am working for two offices. I'm working for NPA, I'm working for SIU as the acting head. So there will be times when I'm not available because I'm engaged at SIU, which is not far from the NPA's offices. So I will divide my time between the two offices. So if I start in the morning at NPA, I will go to SIU in the evening and into the morning of the following day. And then, do it like that, depending on what the issues are. Sometimes I'll start at SIU. So it was anticipating that in the event that I am not within reach, or I'm not reachable, not within reach, I'm not reachable for the NDPP, that Tobile would be there to be the person who is available for her for any legal requests which will warrant my urgent attention. So that's how we put him then in place.
Would it then be expected of Advocate Chita or Mr. Chita to deal with issues in your absence, your physical absence, of course, and not keep you in the loop, as you say?
There are
Is it okay? Is it regular? Is there nothing wrong with it?
It depends on what is at issue.
The issues are.
If it's a question of filing a document, compiling a memo for briefing of counsel coming from a particular division from their instructions, which do not warrant any legal input whatsoever, then it would not be needing my attention. But in all those material, which he would understand that this is material, it requires my attention as the head of LAD, he would certainly have to do that. So where I am aggrieved that I'm not kept in the loop is on the material facts. I'm not picky as to whether it's the Department of Justice which asked for an opinion from one of the NPA employees. It's all within government, and in fact other government departments have also asked for opinions from us, and we have not been stingy with the assistance. So if there's an existence of a memo to brief counsel, it's just to brief counsel. It's an admin something which does not necessarily even need me, because then if it is a Boysen matter, and the Boysen matter is sitting, I think in the SCCU space, there is a special director there, there is the head of NSSD, who would then be the one who, it's from my division, then okays it, then it will go to the NDPP, then to the CEO for final say that there are funds we can brief. So it's not something that I will be picky, that keep me in the loop with that exercise. It's just to assist. We've assisted many people with their memos for overseas travel, motivations for those things, your OECD, your FATF, if anything for that matter, we are now and again asked. So even admin personnel will then be asked from other divisions within NPA to assist with certain things. So we do assist each other. But insofar as the actual involvement, LAD was not involved in the Boysen matter at all.
As far as you are concerned, because you were not involved.
I was not involved, and there's no book out of the Boysen matter to anyone. We didn't deal with that, except the suit of malicious prosecution, which then now came from Boysen himself. It is dealt with at LAD.
Because it's a civil matter.
It is a civil matter.
Okay. Thank you.
Thank you.
Just arising
Miss-
from
Oh,
from those
okay.
questions, just so we are very clear about it, are you aware that even today, Mr. Krita is in fact dealing with the poison matter?
I'm not at LAD. Willie
You're not
Hofmeyr-
aware?
Willie Hofmeyr will know that. I'm not aware.
Yes, but that's the
Okay,
case.
I'm not aware.
Okay, thank you, Mr. Masuku. Mr.
Thank you,
Red,
ma'am.
It's your turn.
We have no questions for this witness.
Oh, thank you. Any re-examination? Ms. Bauer?
Let me seek to clarify a few things with you quickly. You were asked, did you at any stage ever get a call from Advocate Jiba to say that she was unhappy about any advice that's being rendered by counsel and that she was going to seek to change counsel in the full matter?
A call.
Any communication? If she was unhappy with Matau,
Outwise.
Matamela, Halgrain, did she raise it with you at all?
No, there was a time when, after I'm assured that we filed our answering affidavits now that the Mutibele team has disappointed us as MPA. But that was not raised in a formal way, but it was because here I am working on answering affidavits, the following year on an urgent basis like that, out of time, and yet we had silk in the
Okay.
matter.
Even with your unavailability, you had, for the most part, when Advocate Jiba was the acting NDPP weekly meetings. Is that correct?
Yes, we did.
And did you manage to attend those weekly meetings?
Yes, I was attending. Some of them I would not be available, but I would, as much as possible, attend.
You were asked this question as to whether you thought you were deliberately, the Clarence Breitenbach / Jan Ferreira memo was deliberately withheld from you or not. You don't actually have knowledge as to what any motive would have been to withhold it from you.
I wouldn't know.
You were asked why you didn't raise with Advocate Cheetah, you were asked why, becoming aware that matters had not been raised with you, whether you had raised it with Advocate Chiba and whether you had raised it with Mr. Cheetah. You said you raised it with Mr. Cheetah and those were his instructions from the NDPP. What was the environment LAD was operating in at that time?
This is at the time when we were trying to establish the LAD, establish the proper mandate, establish the protocols around referrals, the processes and the policies, guiding as to what needs to be done in whatever matter and how. This is, as we are coming from February of 2012, where we are looking at the structure of NPA, that, LAD, some of the sentiments were that, what is this LAD? We don't, LAD, what is this? As far as we know, there were 4 DNDPPs in terms of the Act, and where the disbandment of DSO then meant that the 4th DNDPP becomes a moot position, if for lack of better words. But then this is a time when I have prosecutors within the LAD, people who are skilled and experts in criminal prosecutions and not necessarily can swim very nicely in the waters with civil matters, to an extent that when Mr. Krita and one other advocate from AFU came to join LAD, I was very happy that I'm now having attorneys and people who are savvy in civil processes to come and assist. This is a time where I'm asking for resources and we can't have any resources, lack of budget, etc. This is a time where I'm asking the DOJ to give me some, personnel who form part of the civil litigation division to come and assist to capacitate, LAD in civil matters. So this is at the time where, after the move of certain services from LAD, that I then lost the DDPP who was coordinating the incoming of the civil matters in the name of Karen Foster, who was then now reporting to the head of NPS. And there was a toing and froing as to who should do what, how they should do it, to an extent that there was a meeting then held with the head of NPS to try and iron out these things. But this is a time where even the legality of the work of LAD is questioned by the other DNDPPs in the weekly meetings that we used to have with the acting national director, Advocate Jiba. So when it comes that the NDPP has instructed this, yes, it is the NDPP's prerogative, but that is at the time, the things were not yet as settled as they are now, where even the DPPs would understand that, matters should be dealt with within the LAD. And as recent as the beginning of February, there was a question as to why is this labor matter not dealt with at LAD, so things have now, settled, but at the time, this was a new division. This is where, trying to establish yourself to get to be, understood by the other stakeholders, firstly within NPA and then outside. We are engaging with the state attorney, we're engaging with the chief litigation officer's office as to how we're going to deal with these things, and certain understandings were then, garnered out of that exercise. So this is a time when I feel that at least the NDPP is utilizing us, at least the NDPP is coming to us, at least the NDPP is engaging personnel from legal affairs division, then we are relevant, then we are needed. So I took it as that.
When you, with the last paragraph in your affidavit, I understand what you sought to convey is you wanted to be clear about the limits of your involvement in the full matter. Is that correct?
Indeed.
Okay, so let me take you, have you still got that answering affidavit of Advocate Jiba there?
Yes, I have it.
Okay, let me take you to paragraph, and I'm going to go via paragraph references in the affidavit. Let me take you to paragraph 72.
I think mine starts at 137, what I have.
Okay, well, let me read you the statement. She says, my citation, she refers to an allegation that's made in the, it might just be easier. You don't have your glasses, so you're not going to be able to read that.
I'll try and squeeze my eyes. 72. I can see though.
It's fine. Cases from here, you just use the arrows to
The last bit of that affidavit is when Advocate Jiba says, I do not personally, or my citation as a respondent in my representative capacity in any matter does not mean that I personally instruct attorneys and counsel to represent me in these proceedings. That is strictly speaking correct, but she would approve the counsel. Isn't that correct?
Yes.
Right. Now, if I take you to paragraph 73, you have already indicated, and I'm not going to take you back there, that here it is stated that the LAD handled all matters pertaining to civil litigation involving the NPA, deals with matters, and it says you're the head of the LAD and you're supported by inter alia deputy directors, 20 senior state advocates and senior prosecutors. You've already testified to what your staff complement was, your views on what they dealt with, and to the extent that there is an inference in this paragraph that you as the head handled all matters of civil litigation, you dispute that?
Not all matters.
Yes. Right. So when you go to paragraph 74, typically when an application citing a member of the NPA in his or her official capacity is received, that application is referred to LAD. You've already testified in respect of your view that it wasn't always referred to LAD, correct?
Yes.
And it then refers to you referring a matter to a member of the team who will then prepare a memorandum and steps to be taken. That doesn't happen in every case, is that correct?
No, as we've now established in the boys, and you know, it
Yes.
didn't come through me, but it happened. But this is the general scheme of things, how things would
Right.
then happen.
In-
If briefed, you will do that. Yes.
In paragraph 84, as with any application of this nature received by the NPA, it was attended to by the LAD. Advocate Tobile Chita, senior state advocate in LAD, was assigned to deal with this litigation under supervision of Advocate Mokgoro. I refer to the confirmatory affidavits of Advocate Chita and Advocate Mokgoro. You did not provide that confirmatory affidavit. Is that correct?
No, I did not.
Right.
I was not presented with one to confirm or to do anything.
So in that regard, you wouldn't agree with the affidavit?
Yes, I wouldn't agree with it because I have not filed a confirmatory affidavit in this matter. This is the GCB matter.
Yes, right. In paragraph 92.3, when it is said that on 28 August 2012, a council furnished a memorandum to the LAD. That is the memorandum which is received by Advocate Motamela. You did not see, and you've already indicated, you did not see that memorandum.
Is this the one I was presented with? It had Noche Mutimele Paswane.
Still, yes, that's correct.
No, not at all.
Right. And then I take you to page 353. I think it's, sorry, give me a second. It's either paragraph 92, just give me a second, I'll find the right.
Sorry, ma'am. Can I just? I'm a bit confused about this re-examination. The re-examination is based on the question I asked when I asked Advocate Mohatla to identify paragraphs in the affidavit of Advocate Chiba, which affidavit she would say fit the allegation that there is an allegation in the affidavit of Chiba that says she has knowledge of certain things that she disputes. My learned friend is taking it through paragraphs of affidavits. Am I to assume that this has been done, this is an exercise that has been done between the two of them? Because she is the one leading her. She is not the one bringing up these affidavits, these paragraphs.
And your objection is?
No, I'm trying to find out what this re-examination is intended to do. If the answer that my learned friend is giving me is that she in fact had a consultation with this witness in which they identified paragraphs of the nature that she's identifying now, then I'm quite happy to understand that is the case. Because the question I asked was her, as the witness, to show us paragraphs in the affidavit of Chiba, which is consistent with the allegation that she is not, that she disagrees with But now what's happening is that the evidence leader is pointing out paragraphs, paragraphs, paragraphs. And we would want to find out what exactly the purpose is in all this. Is it her evidence or is it the evidence of the witness?
I'm happy to
Can you
not lead.
respond?
I'm happy to not lead, but in essence, Advocate Mogatli has already given us the evidence. I'm simply associating it to paragraphs. What the question was can you point to any paragraphs? Advocate Mogatli's response was, I can't do that right now. I would have to go through. I didn't mark it in my affidavit. And the question was, I have read Advocate Chiba's answering affidavit. I deny any allegation contained therein regarding my knowledge or conduct to the extent that it is in conflict with what I've set out. The exercise I'm doing emanates directly from a question in cross-examination.
You are raising, no,
Sorry, ma'am.
you are raising issues, let me just get it clear. You are raising issues which arise from cross-examination, and you are locating the issues or your questions, locating the paragraphs where the questions regarding what she has already been cross-examined about have been raised.
Sorry.
Let me give you an example.
In other words, this is not new
Ma-
issues
Sorry, Madam.
that arise, but even if it is new evidence that arises, remember, we have agreed that if there's any new evidence that arises, you will get an opportunity to cross-examine on those issues.
I think he makes
Yeah.
a different.
So, Madam Chair, if I can
Yes,
just
sir.
throw in my 2 cents worth here as well. We're not directly involved with the evidence about Advocate Jiba's veracity in the affidavit or not, but unfortunately, what we're seeing this afternoon is a bit of a pattern that started and is getting, in our humble submission, worse and worse. And I'm not casting aspersions at anyone, it might just be the time and whatever it is. But the way in which this witness is being led now, we will submit, makes her evidence absolutely worthless and meaningless. Because-
Re-examined.
Because she's being re-examined, was purportedly re-examined, but she's being led, because not only is she being taken to the paragraphs, she's also being interpreted the paragraphs by the evidence leader, and then all the witness has to say is, yes, that evidence is completely, totally useless with respect. And we're seeing a lot of it, and I know we're not in a formal court, and we know we're not bound by pleadings, but there has to be somewhere where this grey area becomes unacceptable, and we would submit what we're seeing this afternoon is unacceptable.
I
with
get your
respect.
point. I
Thank
get
you,
your
Madam.
point. Ms. Bauer, would you re-examine or approach your re-examination without leading or giving the impression that you are leading the witness? Re-examine in the ordinary manner of re-examination. In other words, approach your re-examination differently.
Okay.
Thank you.
I'm going to refer you to
But my lady, sorry, Justice Mokgoro, that's exactly the problem. That what she is doing is leading the witness to paragraphs.
Yes.
We asked the witness to show us
I
paragraphs.
have asked her to do it differently. Yeah. Not
Can
to
I-
lead the witness, but to re-examine her.
Can I find out, Mr. Masuku, the witness, in answer to your question, and I agree with you, said, if I'm given an opportunity to do so, I will do so. And therefore, I ask the chair whether isn't it more appropriate to give the witness time to look at that affidavit for our assistants to then point out or not point out, instead of Ms. Bauer going through it.
Yes. No, I mean, the evidence has to come from her. She has to be the one that says, I looked at paragraph so and so, and this paragraph is not consistent with what I know. And it's not fair for the evidence leader to be the one pointing
To
out.
point to the paragraphs. I understand that, yes. Will you? Do you want to continue with your
yes. Let me
re-examination?
ask it differently.
Yes,
In,
thank you.
in paragraph 92.7, you are referred to in the affidavit. Her
You're doing
name is
it again.
referred to in the affidavit.
No, no, no. Can you just ask her, re-examine her, and let her come out with
Can I find out,
the
Mrs.
evidence?
Bauer, so
Otherwise,
that,
give her an opportunity to go through,
Is
go
it-
through the affidavit.
can we stand the matter down for the witness to go through the affidavit?
We can do that.
And because
Sarah.
she's essentially has been under cross, she does it without your assistance. She goes through the paragraphs. She's intelligent enough, and I know her personally, to be able to do that herself. So shall we give her that chance? Because there's an issue about how you're doing it, and it doesn't get cured by you still going to specific paragraphs.
I would
And she has asked, previously, she has asked to go through the affidavit so that she can identify the paragraphs that she was cross-examined about. Okay. Can we
Yes.
just stand down for a while so that she goes through it and identify the paragraphs that you said you would want to, yeah, okay.
Have you finished
Before
with
that-
your re-exam?
Well,
No, no, no,
other
she
than that,
hasn't.
so admittedly, I was looking for a shortcut because it's a 92-page affidavit. So we would need to give her a copy so that she could go through the 92 pages.
If I can just be given 5 minutes is
I
sufficient.
think you won't take too long. You won't take too long.
Yes, 5 minutes is sufficient. I
And
would
you know what
appreciate.
you're looking for.
Indeed.
Thank you. Can we just, we'll give you double your 5 minutes, okay? We'll give you 10 minutes. Mr. Masuku?
In the 5 minutes she's doing that, can we deal with one housekeeping matter?
Sure.
Mr. Arense is now available on the 26th of February to lead
I'm not.
Advocate Jiba. She's available on the 26th. She pushed, she can be available on the 25th, but she arrives, sorry, I apologize. He's very handsome, so maybe I just, you know.
To wonder what's going on here.
Yes, he would kill me for this, but what I mean, pushed. He would be available on the 25th, but he arrives that weekend from the UK, and he just wanted one day to prepare so that he can work on. He can do the leading of evidence on the 26th.
You remember I had indicated that we are working on the schedule as is. As long as that doesn't go off the rails of the schedule that we are in, because groups of this team and individuals in those groups have pre-arranged commitments, and we had struggled to put together a schedule that suits all of us. If Mr. Aronsa is available on the day that we had expected that you will lead Ms. Chiba, then I think there would be no problem. There should be no problem. But if it kicks us off the rails, then it is something that would be difficult for us to accommodate. Okay. You understand what I mean?
Is the answer that I should tell him that the
As
panel?
long as he is just coming in where you were supposed to be,
Because
leading.
it was
and it doesn't change our schedule.
right from the beginning. It was a specific request put to everybody
Yes.
that Mr. Arense would lead the Advocate Jiba. It was right from the beginning.
From the beginning,
Yeah.
and then there were a number of changes made, and we gave an indication that our timelines and the outer limits of our timelines are such that we need to stick to the schedule as it has been reconsidered as at the day when Advocate Aronsa said, you will proceed with Ms. Chiba's leading. But if he wants to do it, he can do it as long as it is done on the date that has been scheduled. No. Because we
If it-
cannot
if it-
change our schedule. It's not possible to
Okay.
change the schedule.
Okay, thank you.
Okay, thank you. So can we give Ms. Mokgatle.
Madam Chair, can we give her another few minutes and I deal with another matter of housekeeping that we would need to deal
okay.
with this afternoon?
All right,
Just
you can do
coinc-
that.
It has been formally confirmed to the inquiry via a letter from Mr. Agrisi's attorney that subsequent to him having received legal advice and with due regard to the rules of our inquiry, he is unfortunately not in the position to give evidence before this inquiry. He further indicated that should his position change in relation to the pending criminal charges against him, he would be in contact. We have, for the sake of full disclosure, provided the parties with a copy of the letter. And so in light of that, we will continue with Advocate Mr. Hofmeyer tomorrow. And I'll ask my junior to actually step out and confirm the time with his legal advisor asked for 11 o'clock as opposed to 10 o'clock, given that she had indicated that she had this person who was driving in from Middelburg and a prior commitment whom she couldn't shift or made earlier. And I am told that she's asked if we can commence at 11 as opposed to 10. It should be enough time for us to complete his evidence tomorrow.
O'clock be acceptable to both counsel? Okay. Mr. Rip?
It's in order with us.
No, thank you.
Judge,
You will not be there.
no. I have every intention of being there. I will be there. May I just ask that we'll deal with this issue slightly differently? Having
The Mokgatla,
No, not the Mokgatla. While Mokgatla is doing
all
what my learned friend refers to as another issue of housekeeping pertaining to Mr. Agrisi. It is not a simple issue of housekeeping for us. Amanda expressed instructions to make certain substantive submissions just around that, not for argument, but to place certain facts on record and Amanda leadership. So my suggestion would be, let us dispose of the issue with reference to Advocate Mokgatle so that we don't detain her with issues that do not pertain to her. And once we have finished with her, then deal with this particular
This
Agrisi
matter.
issue.
is that all right with you?
It's fine.
Also not seen that letter, by the way, so in the intervening period, we could just be given a copy of the letter so we can interrogate it.
Yeah, just received, so you need to, yeah, it's hot off the press. You may give it. Yes. I think you're quite right. There's probably a way to deal with it. Ms. Mokgatle will let us know if she's ready, or whether you need more time.
Only 5 minutes.
You're fine. I think we'll leave Ms. Mokgatle to prepare herself. adjourn. I almost said if Mr. Arendse would be here, we would say, let's take a comfort break. We can adjourn for 10 minutes. We adjourn for 10 minutes.
Yeah, I'm not sure. Don't know when this starts.
But you was here, buddy.
This is the third week, so 2 Mondays ago.
3 Mondays ago.
Sorry, 3 Mondays ago, because I wasn't here.
You were here on the first day.
Yeah. Yeah, 3 Mondays ago.
Yeah, 21st, then go back to Gary and share it.
Thank you very much. Are you ready for us, Ms. Mokgoro?
Yes, Chairperson, I'm ready.
Ms. Bauer?
I'm going to leave it over to Advocate Mokgoro to answer the question, which she's well aware of.
Thank you.
And now I didn't speak to her in this period as well, in case that gets asked.
She did say I must drink more water.
Okay. If that will help, it will help all of us. Thank you.
Thank you for the indulgence, Chairperson. Just outright, I would like to refer to the pages that I will be referring to. It's page 344, 345. Yes, paragraphs. Oh, I beg your pardon. It's pages in terms of the paginated papers of the drop box, the bold number at the top.
You have paragraphs for us?
Yes,
Paragraphs
I'm
on
going
that.
to now also refer to paragraphs, just for in case something is missed. It's pages 344, 45, 47, 350, 357, 373, 374, 389, paragraphs starts from paragraph 72, paragraph 73, 79.4, paragraph 84, paragraph 86, 92.3, 96, paragraph 117, paragraph 162, if we may start with paragraph 72, which now I don't remember the page. Paragraph 72.
Page 344.
This paragraph, as I understood it in the body of Advocate Jiba's affidavit, is that LAD is seized with briefing counsel in all matters, that she does not brief counsel directly, but I already said in my testimony that in matters where the NDPP is cited, it is finally the NDPP who has the final say in the choice of counsel. Yes, we do give the hands in facilitating that, but the decision will then be finally the NDPP's. If we move to paragraph 73, it comes back to that again. This is where the affidavit says the division is seized with all matters, but it has transpired that not in all matters would LAD be seized with the matters. The example would then be the Boysen matter, just the one that we were talking about. If we go to 79.4, talks about Halgrain and bearing coming from paragraph 72 and 73, that it is LAD which will then be the one who deals with these things on behalf of the NDPP. I've already testified that anything to do with Halgrain I would not know of. That's why I'm highlighting paragraph 79.4 so that it just it's taken out to indicate that LAD, as in me, the head of Legal Affairs Division, had nothing to do with that. But the premise that comes from 72 and 73 is that it is then the head of LAD. Paragraph 84 is dealing with a confirmatory affidavit. Is that paragraph 84? If you go down, the confirmatory affidavit, I've already said that I was approached at some point that would I be amenable to doing that. I said yes, but I have not been approached or given one confirmatory affidavit to depose to, nor was I given the affidavit of Advocate Jiba to confirm. So insofar as 84 is inconsistent with my involvement or conduct, which I refer to in the last paragraph of my affidavit for this inquiry.
Other than the confirmatory affidavit, the content of what is said at 84, that you were assigned to deal with the matter under your supervision, is that correct?
I am the head of Legal Affairs Division at the time. Tobile Krita is an employee who reports to the head of LAD. So he was supervised by the head of LAD. But then in some instances you would find, as we have already canvassed, that some of the events that occurred were not run by me. I was not party to that. So it would not be true that the entire, everything that happened in the FUL was under the supervision of the head of LAD. Paragraph 86. The record, I've already testified that the Mutimele team, we did not discuss anything about the Rule 53 record, and even the memo that I have not seen, I'm not sure if it comes from them or not, given that we have now come to know that some documents are not authentic. Even that memo from Advocate Mutimele, Noche Paswane, at the bottom, that's what is written, it's unsigned. There is no talk even of the Rule 53 record. And I'm also saying this because at the time Advocate Mutau was on brief, he was talking about the filing of a Rule 53 record, hence we were at pains to go and look for the documents that he then required, and this was in June of 2013. So that will then be inconsistent with there having been talk of a Rule 53 record. Paragraph 92.3. Now, insofar as the gist and the understanding that is drawn from Advocate Jiba's affidavit is that LAD would then deal with everything that needs to be dealt with. And this paragraph is saying, on the 28th of August 2012, Council furnished a memorandum to LAD in which they indicated the course of action to be taken when filing the record of the decision. Now, I'm taking this to be referring to the Mutimele team, to which we never discussed any Rule 53 record with them. Paragraph 96.
You accept that it makes no reference to you, this paragraph?
I understand that, but the import of the affidavit of Advocate Jiba is that decisions on this case, everything on this case, it is LAD, it is the head of LAD, but then now we can see that there are some instances where the head of LAD was then not involved, therefore inclusive of the Halgrain briefings, etc., because the premise that comes from paragraph 72 and 73 is that this will then be on the head of LAD's desk when it is not. That is why I highlighted in my affidavit that insofar as it is consistent with my involvement and conduct, I'm not mentioned by name, but LAD is mentioned. So my understanding when you mention LAD, it means I'm involved. But if counsel earlier on when he said reference to your name has not been made, when it says NPA team of representatives, it does not include you. But here now it says LAD, and I'm head of LAD, and it has already been said in some paragraphs prior to this one that I'm the head of LAD, and everything that happens under LAD is under my supervision. Yes, that I am in charge of, that I am looking at, unless somebody is doing something without my knowledge, then I would not have supervised that. So that's why I am highlighting this. Where am I now? I think pages, on what page are we now? This is page, can we move up so that I can see if I've touched on the pages. This is 357. Then we can go to page 373. I think it's paragraph 149, if I'm not mistaken, or if it's 100.
You had earlier given us the reference, page 373, paragraph 96.
Okay, so in general, if you look at this page, there is talk of Advocate Halgrein. I was not involved in the Halgrein. That is why I also now say LAD is in me. I was not involved in that process. And this is a process that is mentioned also in Advocate Jiba's affidavit, and there is a memo which I earlier on questioned the authenticity and even existence, that is it a real document or what? It seems to, it doesn't seem to, it talks about Halgrein being briefed, etc., etc., and then it's part of the Advocate Jiba's affidavit. And I was not involved in that, so that is what is inconsistent with what my conduct in the case, hence I'm highlighting that.
Sorry, Advocate Magatli, I misled you. You had said to us paragraph 96, and it's actually on page 357.
It's 357, 96. Paragraph 96 it's referring to, I returned, it's about the briefing now. It is, I was briefed about this matter, and then this is the memo that I referred to of the 16th of May of 2013, which I say I don't recall, I don't understand it, because as far as I'm concerned, Advocate Jiba is working closely with Krita. There is counsel in the matter, so there was, for me at that time on my table, nothing to brief Advocate Jiba on. So I did not do that in terms of paragraph 96 as it's put there. Then from 357 we can move to page, I think this is 373 and 373. Now, the briefing of Advocate Halgrein again coming up in 140, which is just a repeat of everything, because I'm taking it from the premise that LAD has been dealing with the briefing and debriefing of council. I was not involved. 374. Will you please blow it up? When you go down, I probably just well, it's talking about the Rule 53 record, but I think I may have just put 374 here. Let's skip page 374. The next page would be 389. I'm hoping I'm right with the 389. We should be talking about filing. Uh, 389. Oh, we've skipped paragraph 162. Maybe let's go back to paragraph 162. Here, in matters that involve the NDPP would make the final say as to who's, I think it's the repeat of what I already said with the other paragraphs, that whoever council would be briefed would then be per the NDPP's approval. So whether or not I was involved in the briefing, then the NDPP would definitely would have been involved in that. I also picked up in the affidavit as I was going through it now that the brief to in the poison matter was then facilitated by Muzing and one of the members of the prosecution team. LAD was definitely, I was not involved in that, and it is specific mention regarding the briefing of council in the poison matter. So this is an answer to council's question about that the poison matter was referred to LAD to deal with, which is something that I would say no to because LAD was not briefed. I think that appears in paragraph 203 of the answering affidavit in the GCB matter. There it is, it's talking about Mayema Matenjwa Musing to instruct holders SE team in the litigation in this matter. So there is your answer, Council 200, page 203. I think I've now dealt with the paragraphs that I was referring to when I said whatever is not consistent with what is contained in my affidavit and my testimony that is contained in Advocate Jiba's affidavit, insofar it relates to me and my conduct, then I don't agree with it.
I have no further questions.
Thank you. No?
No, I have no questions for this witness.
Okay, thank you. Mr. Rip?
No, we have no questions for the witness, thank you.
Thank you. We've come to the end of this proceedings, and Ms. Mokgoro, thank you so much for availing yourself to assist the inquiry. It's much appreciated. Okay.
Thank you.
Thanks for taking the time, and you may step down.
Thank you.
Thank you. We will then complete our housekeeping discussions. Mr. Majavu, you wanted to put something on record?
Thank you, Judge. I undertake not to detain us longer than necessary. And before I commit a cardinal sin, happy Valentine's Day for the balance of the day.
And not with a wilted rose. Aibo.
It's the gesture, Judge, that counts.
It's the thought that counts. Thank
Thought
you.
plus gesture.
Thank
Judge,
you. Yeah.
the purpose really of my brief address is as follows. Firstly, we want to make it absolutely clear from the onset that we take no issue with the evidence leaders with specific reference to reporting on the outcome of their engagement with Mr. Agrizi. We accept that you are sitting as a tribunal with no force of compulsion. And the only reason why I'm instructed to deal with this matter substantively and not just as a mere housekeeping issue is as follows. Firstly, at the commencement of these proceedings 3 Mondays ago, the preceding Sunday brought about a situation where certain testimony was leaked with specific reference to advocates Jiba and Mokgoro. I hold no brief from Mokgoro, and it preceded the commencement of the proceedings. And Chair, you would remember that right at the very onset of the proceedings, we did take the inquiry into confidence to say, this has been brought to our attention. Advocate Jiba's position is that she's taken note of the allegations, and as and when they have been formalized, we will deal with them on that basis.
You mean the evidence which was laid?
Not before us.
Not before
us. Yes, I'm simply
before
trying
the-
to, yes,
yeah.
because it is a matter that we raised in this inquiry. And having
Perhaps for the record, you should indicate the evidence that was laid before
the Zondo
Zondo
Commission,
Yes.
about which we addressed the Mokgoro inquiry right at the very commencement. We place it on record that while it was not evidence before this inquiry at that stage, our client accepts that to the extent that it may be evidence received in this inquiry, it would be relevant to the scope as contemplated in the terms of reference. To that end, in fairness to Advocate Bauer, she also concurred that she was aware and she had in fact undertaken to write to the Zondo Commission to seek clarity and also to ask for a copy of that affidavit as and when that evidence is laid before Zondo. At that stage, it was nothing more than media leaks. In the intervening period, that evidence was subsequently laid before the Zondo Commission. And after we had dealt with that issue as a preliminary issue before you, Judge, you also quipped that we can all accept that it is not evidence before this inquiry, but we will play it by ear. To be fair to Nes, Advocate Bauer, she did 2 weeks ago provide us with the affidavit which she had received pursuant to her writing to the Zondo Commission for purposes of it being evidence before you. That was shared with us. That then resulted in the toing and froing about the scheduling of our program, and you will all accept that as per the revised program as it stands, Mr. Agrizi was due to testify tomorrow before the Mokgoro inquiry or at the very least insofar as it relates to Advocate Jiba, to be subjected to cross-examination to have the veracity of his evidence tested. We all worked on that basis. We also understood that he had initially indicated that he was not going to come. Last Monday, we were told that he was in fact going to come. That's why we penciled in tomorrow. But there was a caveat that subject to him taking legal advice. Now, we've just been informed that he has now taken legal advice and he has adopted the position that he is going to invoke the right against self-incrimination in terms of Section 35 of the Constitution. We do not intend debating the correctness of that approach, other than to accept as a fact that we now know he is not going to come before us. The relevance of that for our client, and insofar as it implicates her rights, is that it is now evidence that we have formally received from the evidence leaders. And we cannot assume that because Mr. Agrees, rightly or wrongly, elects not to come before us or before you, then automatically it means, as of right, his testimony would be totally ignored. We also accept that those allegations are still hanging and in the public domain. And interestingly, at the triggering event, which is before the Zondo Commission, the Section 35 right was not invoked. Now, you are sitting, notwithstanding the fact that you've got no power or force of compulsion, we submit that you are nonetheless a proper constitutionally established tribunal whose primary objective is to establish the facts that would then lead to an answer of the fitness or otherwise of our client to hold office. You were established under the hand of a presidential proclamation, which authorized you or empowered you to also promulgate the rules. And those rules were promulgated. And I just want to make reference, you don't have to go through it, Judge, because you probably know it better than I, that in terms of 3.3 of the rules, which is found in page 5 of the rules, the following is said: a duly sworn or affirmed witness statement and documentary information filed at the inquiry will constitute evidence, save where the chairperson decided otherwise. All evidence to which the chairperson will have regard will be made available to the parties unless the chair directs otherwise. We accept that that has happened. It has been made available to us. 3.4 then says, given the nature and the material to be considered during the inquiry, any other evidence obtained will be by way of an affidavit, sworn statement. In this case, we've received an affidavit. Deponents to the affidavits must be willing to give oral evidence and be cross-examined should they be so requested. We've availed ourselves to that right. Failure to avail themselves on request for an oral hearing and or cross-examination, our emphasis cross-examination without cause, is likely to impact on the weight being afforded to such evidence. And the simple point that we're making, and without necessarily inviting any argument, is to say we, in the fullness of time, will make a submission, which I'm foreshadowing now, that the evidence of Mr. Agrees, insofar as it has been made under oath, albeit before Judge Zondo, must be completely disregarded for purposes of this inquiry. My client was prepared to accept it, appreciating the import of those allegations, whether found true or not true, because even better than Judge Zondo, and I say this very guardedly, you are probably the most constitutionally established tribunal that can legally inquire into my client's fitness to hold office or otherwise, because you are established for that specific purpose. So said the billboards behind us. Now, we could not be seen not to have taken note of that or adopting a stance that we will deal with it when we get to Zondo. Judge Zondo's terms and timelines are a lot more generous than yours. We're dealing with a situation of you being under pressure as it is, because a report must be generated by no later than the 9th of March. So we make these submissions against that context, and not to say we do not appreciate or recognize. I hold no brief for Mr. Agrees, and quite frankly, I couldn't care less. I care less about and more about Advocate Jiba, who has the same constitutional entrenched rights that must be counterbalanced against all these competing considerations. And we are stuck with that situation. And it cannot be right and just for these allegations to be left hanging. Your inquiry will come and go, and depending on which way you find, and by all means, I'm not suggesting that we're presumptuous about it. If you find or you answer the question in the negative, it's pretty much game over for our client, or close to game over. But if it is answered in the affirmative, there is a real possibility that post your findings and your report, it may well be that the president may be minded in the direction of another 12-6 to inquire into her fitness to hold office in the light of these allegations that would remain untested, certainly before Judge Zondo. And we're raising that purely to say we are placing it on record now that while we accept that nobody in this room can force Mr. Zondo to come here, no, Mr. Agrizi, I beg your pardon and I apologize to Judge Zondo.
What is it, a Freudian slip?
A Freudian slip and a Majavu slip, and I take full responsibility for that. But the point Judge Beam made here is that we understand that it is what it is. Mr. Agrizi has invoked Section 35, which deals with detained or accused persons. I remember vividly what you said as an opening salvo of these provisions. You told us what this inquiry is not about and emphasized what it is about. And it was also emphasized that the rules of fairness, justice, and equity must animate these proceedings throughout. Now, it cannot be correct, and I say this in all humility, but with the firmness of conviction that I can amass, that my client's rights cannot be sacrificed at the altar of Mr. Agrizi's invocation of the right against self-incrimination. He has already spoken about the issues in public where he did not mount this defense. My client has already been labeled a snake without any due regard to her rights. Now, it may well be that what Mr. Agrizi is saying is true. We don't know. But you are the trier of fact, and only you could have, with the help of Mr. Agrizi, assisted us to come to that definitive finding. So the submissions that we're making are simply to buttress that point, to say our client is extremely displeased by this recent turn of events. And I lay that Damascus Road experience at no one's door other than Mr. Agrizi himself. So we accept that the evidence leader did what she undertook to do. We are sitting in a situation where we've got evidence that we've received. And as I conclude, Judge, I'm going to implore the panel to take this into account, or take judicial notice of this. And in the fullness of time, that will be more eloquently be addressed by my seniors, but it is something about which one was instructed to place it on record so that South Africa knows that Advocate Jiba was prepared to confront her accuser in the form of Mr. Agrizi tomorrow. Now, she will no longer have that opportunity. As a parting shot, we received a letter, Judge, that was circulated before the adjournment. And paragraph 4 of that, speaking for myself, is extravagantly insensitive to my client's rights. It says, we wish to state that should our client's position change in relation to the pending criminal, we'll immediately contact your evidence leader in this regard. So it is clear that the reason Mr. Agrizi, at least on a cursory reading of this letter, is that because of the impending criminal case, he is now no longer prepared to come before us to have the veracity of what he said before the Zondo inquiry tested. And we accept that. He is acting on legal advice. The same legal advice that my client acted on when she said, before you, Judge, I've taken note of these allegations. I'm happy to deal with them in any tribunal, especially this particular tribunal, because at the end of the day, her fate is in your hands. And the person, beyond the judicial criticisms, Judge, we can all accept that the single most important allegation against my client that falls squarely within the parameters of your brief is the allegations made by Mr. Agrizi. But unfortunately, by tomorrow we'll be sitting none the wiser. But those are the submissions, and I do not want to spoil the Valentine mood unless if I'm directed to deal with any issue. And I want to place it on record, Judge, that we're taking no dig at the evidence leaders. We accept what has been placed on record. And I thank you. Ke a leboha, mme.
Ke rona re lebogileng, ntate.
Thank you, Judge.
Madam Chair, might we, whilst this issue has now come to the fore, on behalf of Advocate Mokgoro, just deal with
Yes, I was
certain...
going to give you a chance.
Thank you, ma'am.
Yes.
We concur with the general approach adopted by our learned friends for Advocate Jiba. Once we were notified that there was a strong prospect that Mr. Greasy would be giving evidence tomorrow, we spent considerable time in preparing to meet the challenge that he placed at our door, and we believe that we would have shown quite conclusively tomorrow that notwithstanding whatever Mr. Mti might have told him and how much money Mr. Mti might have defrauded Busasa out of, our client certainly is not linked to these allegations. Unfortunately, we're not going to have that opportunity. But we do believe that perhaps before the evidence is led, and this is something I'll take up with the evidence leaders and my colleagues, we should maybe have a ruling on this issue of what or whether or not the Greasy affidavits will be taken into account at all, because if not, if they are to even be considered in the slightest, we shall have to deal with them in our evidence in chief when our clients, certainly when Advocate Mokgoro gives his evidence and present to the world the falseness of the accusations against him. So perhaps we can do that sometime between now and or Wednesday morning or something of the like, and we'll know then where we stand. But that we just like to place that on record at this stage. Thank you, ma'am.
Thank you so much. And in the meantime, I would ask you to look at rule, what is it, 3.3? Is it 3.3?
Judge.
Yeah. Suffice to say that 3.4?
Read together, Judge, yes.
Read with 3.4?
Yes.
Yeah.
Thank you,
In the
Judge.
meantime. Okay.
Yes.
But thank you so much for those submissions. Okay. You want to respond?
Madam Chair, maybe to say that I don't disagree with Mr. Majavu's sentiments about Mr. Greasy not testifying. We are mindful that the one change in circumstance has been his arrest, which his legal representatives were quite frank with us about when we had made the initial overtures. And to maybe place the thing in a principled question, we have in folder M, which was the affidavits the evidence leaders put up, there are 26 different affidavits. We have not led all these witnesses. And we have accepted that we under Rule 3.4 that there would be an impact on weight being afforded to evidence where the legal representatives for Advocates Jiba and Mokgoro are not afforded an opportunity to cross-examine those witnesses. So I don't think in principle we're there. We do think that it's not necessarily a question of admissibility, but weight. That's the only distinction we put.
And there is probably also, maybe from my perspective, hope that you might get the opportunity to cross-examine Mr. Agrisi because he has not completely closed the door.
I wouldn't hold out that
And
hope.
that, no. I mean, from the letter, it does seem that he has not completely closed the door. So we don't know what will
Judge,
happen.
whatever the position may be, we want to unambiguously place it on record that we'll relish that opportunity because it's a matter of sufficient importance to Advocate Jiba as a mother, as a person, as a professional, as an officer of the court. So the reason why she particularly instructed us to raise this was in the light of the timelines that are already animating our progress. As matters stand, we're on the 14th. If he were to change his mind in a week or so's time, the odds of us dealing with it effectively are greatly reduced. We have also to count back the number of days that you would require to put this mammoth report together. That's really the point we're making. Our best point would be complete exclusion. If you're not with us on that, obviously it will have to be about weight proportionate to his refusal to come before us. But I deliberately said those will be argued in the fullness of time. But I wanted to foreshadow that by raising it today in the light of us not proceeding with him tomorrow.
But thank you for the teams for raising it. We will give it some thought. And I wish to thank you for your participation today. And on that note, we shall adjourn until tomorrow at 11 o'clock. Thank you.
What is? You still want?